The record will show the presence of the defendant and all counsel. The jury is not present. Mr. Nurmi, you have a motion.
Yes, Judge. At this time, we're going to renew our motion for sequestration of the jury. Last night, there was apparently, however they were obtained, at least at this point, we're not for sure, interview tapes of Ms. Arias' parents in Wairika, California were obtained by the media, as well as journal entries from Ms. Arias' entire journal that was seized during a warrant. These were broadcast and read ad nauseum in conjunction with this motion and in conjunction with the reports. One of the reports mentioned that the county attorney's office had provided these diaries to Ms. Arias. So consistent with this motion and also the corollary of the misconduct motions that are still pending before this court and are cumulative in nature, we would be asking that the county attorney advise the court either deny having done that or concede having done that on the record at this time.
Mr. Martinez?
I don't see the relevance of whether or not the county attorney's office provided that or not. That's an issue beyond my control, but my understanding was that there was a public record request. I don't know who made the public record request for the two videos that Mr. Nurmi's talking about. They actually don't watch the media as much as the defense counsel seems to, so I don't really know whether or not that was played or not. Additionally, there was a public record request, my understanding, for the journals, and that was something that was provided. There are many public records requests that are pending for the Maricopa County Attorney's Office right now, and I don't know what they all involve, but I do know that there are many.
Well, judges, this court knows, and the case law tells us that this case must be tried in the courtroom, not in the media. That's one of the boundaries. If we want to try this case outside the courtroom, and that's what the county attorney's office seems to be conceding now, I'm willing to do that as well. But as it relates to the jury, this is the kind of information we've just heard the county attorney's office concede that they are putting out there, that the jurors can hear. If we are to believe, the court asks the question of the jurors every morning, have you seen, or not every morning, on a weekly basis, have you seen anything on the media in a group? No one raises their hand. No one wants to be singled out. But to believe that to be true is to believe in absolute fiction. It is a fairy tale to assume that this jury is not hearing any of this. It is all over the news, be it local or national. So again, if this release of information done by the county attorney's office, this does affect Ms. Arias' right to a fair trial, it is disseminating information that would not otherwise come before the jury and affects her right to a fair trial. If we are to believe this fiction that the jury doesn't see any of this, okay. But again, it is a fiction that is beyond belief. I might add to this, coming in this morning, I saw the media photographer, who I believe works for HLN, move forward towards the door as he saw the jury bus. Jurors number 1, 4, 6, and 17, and I believe 13 were all coming in. I do not know if they were photographed or not. At this point, I couldn't tell based on the way the position that the gentleman was holding the camera, but we have to concede these facts as well. These are facts that the jury is not excluding. There is no doubt about it. We don't even need to rely on a fiction to know that the jurors were photographed this morning or cameras were outside there this morning, because I witnessed it myself. So, Judge, given all this, I'm asking the court to no longer rely on this fiction that this jury is not seeing any of this media and sequester the jury immediately.
Mr. Martinez.
I'm not sure where defense counsel gets the legal authority or the clairvoyance to know what the jurors are thinking or what they're seeing. Again, it appears that defense counsel is much more preoccupied with the news and what is being broadcast than actually listening to what the jurors are saying. It is problematic to say that the jurors are lying, which is what he's saying, when he has nothing to back it up. The jurors have been on numerous occasions, I don't know how many, been asked whether or not they are subjected to any media coverage, and they have all answered uniformly that they have not. There is no reason to believe that the jurors are watching anything if they say that they are not. So I would ask that the court deny defendant's request to sequester the jury. It's a motion for reconsideration under Rule 16. I don't see that anything has changed. The jurors have indicated that they will abide by the court's instruction, and that's what we have to rely on. We can, of course, fictionalize what we believe that they are seeing or not seeing. They have indicated that they are not seeing anything. We can question them again when they come into open court, and I believe that that takes care of the matter.
All right, the court has repeatedly admonished the jury to avoid media coverage during the trial. I have inquired on a regular basis to determine if any juror has seen or heard anything about this case in the media. I have inquired in the courtroom, and I have inquired of the jurors one-on-one in chambers with the parties present. There is no indication whatsoever that any juror has failed to follow the court's admonition or has seen even inadvertently any media coverage of this case. Based upon the law in this state, I am denying the request to sequester the jury at this time. As authority for this court's decision, I am citing State versus Shad, S-C-H-A-D, 129 Arizona 557. State versus Atwood, 171 Arizona 632. State versus Bible, 175 Arizona 574. And State versus Tyson, 129 Arizona 551. All right. With regard to the motion for mistrial that we heard testimony on last week, I understand that the additional witness is available today. Mr. Nurmi, did you want to call that witness at some point today?
Your Honor, has the court reviewed Exhibit number 2?
I have not, but I will over the noon hour. I thought you wanted to present it during the...
I would like the court to review it and then have the Ms. Wong, the witness, the opportunity to review it as well.
Okay.
Right now, as a concern, given that Ms. LaViolette was ill and her schedule, I'm interested in moving forward with that. Certainly, if time can be made elsewhere, we can pick that motion up.
All right. Ms. LaViolette, please come forward and take the stand.